Welcome back, everybody. This is part 3. If you want to read the judge's order and dismissal on this case, it's at the end of the video. Do me a favor, like, share, subscribe, leave a comment down below, and let's get into it.
Your Honor, I'm sorry to jump before you're leaving. Could I just have there be an order that Sergeant Long not discuss any testimony because he's still testifying?
He knows he's on the bench.
Thank you, Judge.
You know you're on the bench. I mean, on the stand.
Thank you, Your Honor.
All rise.
Thank you, Maybe Sadie.
On record.
We are back on record. We have all of the parties and the witness. Mr. Security.
Yes, Your Honor.
And sorry, I just had one follow-up clarification question for Sergeant Long, just so he could clearly identify, since Your Honor is in Anchorage. Is this Ms. Cloud? I guess it went away on the screen, but this individual, is that Ms. Cloud, the clerk of court in Palmer?
It's hard to see here, but I believe it is from what
And I
I saw
lost
briefly.
connection as well.
My tech is very finicky.
Okay. Just so Your Honor is able to identify all the individuals on the body cam.
Yes, in the red shirt, and the black vest.
The clerk
On
of
the
court
right.
in Palmer, correct?
Yes.
Now, which video is this from?
That was from State's Exhibit number 1.
Can you keep it plugged in real quick?
Oh, sure.
Appreciate that. I'm gonna need you. May I proceed, Your Honor?
Go ahead.
Thank you, Judge. Good afternoon, Sergeant Long.
Good afternoon.
Sergeant Long, are you the person in charge of the Palmer Courthouse?
No.
Miss Cloud, who you just pointed out, Babs or Barbara Cloud, she's the clerk of court in Palmer?
Yes, or at the time, yes.
And at that time, when Mr. Lawler was arrested, did she personally trespass him?
Say the question again.
Yes, sir. At the time that Mr. Lawler was arrested, did Miss Cloud personally trespass Mr. Lawler?
No, not at that time, no.
Did she ever?
Not directly, no.
And that's what I mean by personally. You'd agree with me that the word, like, I'm personally speaking to you.
Correct.
So Barbara Cloud did not personally trespass Mr. Lawler, correct?
No.
And you arrested Mr. Lawler for trespass?
Yes.
And trespass is a misdemeanor.
Yes.
Do you have a warrant to arrest Mr. Lawler?
No.
That second time in February,
Mhm.
did you tell him to leave before you arrested him?
No.
So you'd agree with me that you did not contemporaneously tell him to leave when you trespassed him that second time?
Correct, because of the November warning that he was advised.
So you're relying on a 3-month-old warning as your basis for having arrested him for trespass that February day.
That's correct.
Understood. What authority do you have, Sergeant Long, working in judicial services in Palmer, to arrest an individual that's in violation of one of these many orders, bulletins, rules?
I don't have any authority on these rules here, Exhibit 2.
So again, none of these rules, bulletins, orders, there's a lot, right? There's a lot going on there.
Yeah.
Okay.
There
And-
it is. Because I had to read them all and sort of analyze it and decipher it.
I'm with you.
I'm not an attorney.
Even if you were, I promise, it's it's what you think it is. So, and I didn't see it. It sounds like you're agreeing with me. There's nothing in any of these documents, any of the documents that you provided to Mr. Lawler, or that other guy that we've got nothing to do with, that give you, Sergeant Long, authority to arrest an individual for criminal trespass for violation of these, correct?
That is correct. There is not a statute, or at least that I'm familiar with, in like Title 11 or any other titles, that I can make an arrest for directly violating these orders.
We agree. Now, my sort of approach to this is two-pronged. One is by the laws of the state of Alaska, which you and I have sort of just discussed. The other is by the trespass issuance that you made, and let's call that its own sort of order. Is that fair? Just for purposes of this discussion.
It's fine.
Now, the statute here, the criminal trespass statute, the actual criminal one, says that in order to unlawfully remain on a premises, you must be personally directed to leave by the person in charge. You agree with me that if we're calling Barbara Cloud the person in charge, she never personally directed Mr. Lawler to leave, correct?
Not in that day. I mean, what you're saying is we're taking two separate incidents, but it's like I mentioned earlier, on direct, it's no different if someone says someone is trespassed from a residence, that's good. Let's say if it's 3 months later, if they show up, they're arrested for trespass.
I remember you saying
And
that.
we don't, it's not like someone calls again and says, hey, they're here again, come out here and deal with it, or they're going to get arrested or trespass them again. If we have an advisement, that stays on there for, depends on the amount of time.
And you're saying 3 months is sufficient.
Yes.
But you trespassed him for life, right?
No.
Well, you trespassed him until the year 2099.
Yeah, I didn't enter that. I told someone to put that in. And I mean, I guess it could be lifetime. I mean, I'm going by the guise of you have to be for official business and you can't record. So unless something was changed or the court permits it.
That's not really what I asked, and I think like we kind of agreed upon. There's a lot going on. Let me see if I can refine it. Let's see if I can take care of the clock here. So, you agree that Barbara Cloud never personally trespassed Mr. Lawler, right?
Right.
Okay. And you're not the person in charge.
When you say in charge, you have the clerk of court, there's a building, custodian or like the building manager. That's also another entity of the court.
So if I were to walk up to you and I would say, Sergeant Long, are you the person in charge of the Palmer Courthouse? Your answer would be?
No.
Okay. Now, you mentioned official business, and I want to touch on that too, but that's not part of that criminal statute. That's part of Sergeant Long's, that's part of your trespass order, right? You said you cannot come back here, Mr. Lawler, unless you're on official business, right?
And he can't be recording. It's two-pronged.
See, that is exactly what I'm trying to get at. Because on one video that we just saw, you said you cannot be recording unless you're on official business. He comes back in February and you say you can't be recording even if you're on official business. You agree with me that's confusing?
If that's what I said, maybe I got confused, but
Wow.
he was told in November it was two-pronged.
Let's go ahead, Ms. Markson, and help me out with the tech here. I'd like to see would it refresh your recollection if we looked at these two instances of the video? Because you're confused, he's confused, I'm confused, but he's the one looking at a criminal charge, so I think it's worth a moment. Now, a quarter into video 2, you said, are you here for official business? He says, yes. So a quarter into video 2, please, Ms. Markson.
Do you mind doing this for him?
Oh, Your Honor, I asked her first and she said yes. I don't know if that's changed here.
Do you want to take over on my laptop? I mean, I don't know what you're referencing, so
What
do you want to plug in your laptop? I guess I just thought you were going to ask, like, pointing out questions. I didn't know you wanted me to queue up timestamps and everything. I think if you want to queue up timestamps, here's this if you need it. I'd probably feel more comfortable because I don't know what timestamps you're referencing.
A quarter into video 2. So if you could play the second video you played about a quarter of the way into it. Touch government laptops. Is that the second video? Which one's the second video?
So are you referencing State's Exhibit 1 or 3?
The second video you played.
So there was 3 videos played for State's Exhibit 1, and there was 2 played for State's Exhibit 3. What specific video are you asking for?
2 of 5. The second one played out of all the 5.
Okay.
And what timestamp would you like?
It's about a quarter of the way into it. Can I touch this? Thank you. Is there a way to get that up there?
Plugged in.
It appears, Sergeant Long, that the big screen is not defense friendly.
Oh, the big screen's not anybody friendly. It's got nothing to do with you.
Big screen doesn't discriminate. So, would you take my word for it that the record in these videos would reflect that on that occasion you said you can't record here unless you're on official business?
And I do have it in the record, so I can go listen to it.
Yeah,
Excellent.
I think that's the best approach. It's just your honor to listen to it.
And then another time you said you can't record here even if you're on official business.
And then my
Okay.
position remains the same. The judge can look back
Yeah.
and listen to the audio.
The record, the recording speaks for itself.
Thank you, Your Honor. And you'd agree with me that those are conflicting, inconsistent, confusing
Yeah.
statements, orders. Yeah, thank you. Now, you said that in the November trespass, you presumed that Mr. Lawler was recording. You didn't actually know that he was recording personally. You didn't actually personally observe him recording, correct?
Not until we were told that he was recording. So, which would be the second video of that. I guess it was the 3 or whatever. When we were told.
Okay, which day are you talking about? I'm sorry, I got confused there. Are you talking about the November date or the February?
Oh, I'm sorry. You're talking November.
I am. I'm talking about the November date.
And I'm sorry. What was your question
My
again?
question was that you stated that you presumed that Mr. Lawler was recording.
Right, and he told me that he was recording later when I contacted him.
Okay. And you said that he did not have permission to record, and you said none that you were aware of, right?
I believe, whatever
What is-
on the record.
And what is the proper procedure for obtaining permission to record within the common areas of the courthouse?
Citizen applies to the court to get permission to record. I think there's a form.
Are you familiar with the form?
No, I think I might have seen it a few times. I've never personally filled any out, but I think I've seen one that was signed or whatnot. And I think, I don't know who approves it, but I believe at least, as far as I'm familiar, was Barbara Cloud, that normally approves it, or her designee.
Now, you were recording within the Palmer Courthouse, correct?
Mm-hmm.
And what gives you, is that a yes?
Yes.
And what gives you the authority to record within the Palmer Courthouse?
With the body worn camera, there's an exclusion.
Exclusion where?
With our duty and scope. I don't know what order it is, but we were told that, and it's somewhere that body worn cameras or recording devices by law enforcement is permitted for doing our duties.
Now, that exception in some order that is in one of the documents that you provided for Mr. Lawler. Are you familiar with the presiding judge's statewide order on use of cameras and electronic devices in common areas of court facilities?
That's at least in Exhibit 2. That's the first.
That Exhibit 2, how many pages is that?
Well, the first, the one you just mentioned, is 4 pages. And then there's another 3AN, looks like AO 20-12. And that appears to be 2. So I don't know if you want me to count up that 6, 8, 9, 10.
What date is that presiding order signed?
Looks like there's a total of 21 pages. Of the presiding judge's statewide order on use of cameras.
Yes, sir.
This one here is March 14th of 2023. And as far as I know, that was the most recent that they were able to provide me.
So you believe that that's the one that controlled on the date of the February offense?
Yeah, for both of them.
Your Honor, may I approach the witness?
Sure.
July 23.
Is that in State's Exhibit 2?
Don't believe it's fine about that. Have them refresh his recollection as to where the exception for body worn cameras are. So what I'm going to show you, because I had the same one that you had, and
You gotta make sure you're near a mic before you're talking.
say again. Oh,
You have to make sure you're near a mic, so you either,
I'll
you can
speak
grab
up.
the,
okay,
you just speak up or grab the,
presiding judge's statewide order on use of cameras and electronic devices in common areas of court facilities.
Mm-hmm.
Is that a yes?
Yes.
I understand, yes, for the record. And would you agree with me that this is signed July 24th, 2023?
Yes.
Would this be the most recent document that would control these 2 incidents that we're here to talk about today?
Yeah, that is a newer version than this one that we were provided.
So it's largely the same. I'd be happy to let you read the whole thing. You're probably spinning like I am from these, but you're probably, we're referring to, I'd like you to look at paragraph 6. This order does not apply to the following. And subsection C, read that for the court if you would, please.
Subsection C reads, use of body-worn cameras worn by law enforcement officers who are at the courthouse on official business.
So here is the exception that allows you to record within the courthouse, correct?
Mm-hmm.
Is that a yes?
Yes, sorry.
It's okay, and go ahead and read subsection B, right above subsection C for the court.
Members of the public photographing, filming, or otherwise memorializing court documents provided to them by a clerk's office.
Mr. Lawler is a member of the public, correct?
Yes,
And he was at the clerk's office, correct?
he was.
And in February, he was at the clerk's office on official business, correct?
Yeah, he was.
What was his official business?
I believe it was something with traffic. I remember seeing a citation, which I think was from Wasilla PD. It was a municipal agency, I know that, but it wasn't ours. But I don't know exactly what it was.
You nailed it. That's an excellent memory. He was there on a citation. You'd agree with me that processing a citation in a clerk's office is official court business, right?
Yeah.
So he's there on official court business. He's recording the interaction with those documents. Would you agree with me that He was there on official court business that day in February.
Yeah.
Now, if he was following your trespass order in November where you said you cannot record unless you are here on official business, you'd agree with me that he was allowed to record that day in February.
If that's what I said, it was a mistake, just an error on my verbiage.
I understand. But you'd agree with me that if that's what you said, and that's on the record, we'll review it later, if that's what you said, and that's what Mr. Lawler heard, and he shows up 3 months later to process a citation, which you just testified is official business, and he records it under your trespass order, he's allowed to record that.
Yes.
You agree with me that it's not a crime to record within the courthouse?
It's not against the statute without permission from the court.
It's not a.
So I guess, yeah, if you're talking a criminal, correct.
It's not a criminal.
Crime.
It's not in violation of a criminal statute to record within the courthouse.
Correct.
Yet you arrested him for violation of a criminal statute, which the sole basis of it was recording within the courthouse. Correct?
Yes, from the discussion with Barbara Cloud in November.
3 months prior.
Yes.
And you were actually on the way to arrest him before you had even spoken to him in February, right?
Well, the second time around, yes. Once we were told he was recording, yes.
You didn't pursue your own investigation and ask him what he was doing there.
No, I saw the phone that was there that was recording.
Are you familiar with 10 codes?
Mm-hmm.
Is that a yes?
Yes.
What does 1080 mean?
That means an arrest.
So weren't you already discussing with Officer Jaime that you were going to 1080 Mr. Lawler while you were walking towards Mr. Lawler in February?
Yes.
So before you actually even spoke to Mr. Lawler that day, you had already decided and were informing Officer Jaime that you guys were going to go arrest Mr. Lawler.
Yes.
Would you agree with me that that is not the most thorough investigation?
Objection calls for speculation.
Can I rephrase your question?
I can build on it. So you said that if you have permission, it's okay, but if you don't have permission, that's not okay. To record.
Okay, what?
Mm.
Permission?
Yeah,
what?
yeah, to
Okay.
record.
Question.
So I'm sorry. Say that again.
You mentioned if you don't have permission, you mentioned the word permission. If he doesn't have permission to record, he's in violation.
Yes.
Did he have permission to record?
Not that I'm aware of. I presume that if he did, the court would have never caught us.
So when you arrested Mr. Lawler, a member of the public, for a crime, you didn't know whether or not he had permission to record.
If the court would have notified us if he had permission to record.
Hang on now. I'm not asking about what the court would have notified you of. I'm asking you to go back to February, and in your mind, as you're walking towards a citizen and you are about to arrest him and put him in custody and deprive him of his liberty, did you know if he had permission to record?
No.
So you arrested him absent knowledge of whether he even had permission to be recording.
Yeah, because I was never told.
Now, I saw in this other video where you stop him and you say, hey, what are you doing here? What's your official business? And he tells you, and I wrote it down because it was so different from the second interaction. You say, are you here on official court business? He says, yes. You say, what is it? You're having a dialogue with him, trying to figure out what he's doing there.
Yes.
But you didn't have that same dialogue with him on the February interaction, correct?
Correct.
And he actually tells you, I'm on official court business. He's got a citation in his hand. It's actually part of evidence that the state collected. He's got official court business in his hand. He's telling you within the 9-second interaction that you had with him in February, I'm here on official court business, and you arrested him anyways, right?
Yes.
Was he creating an imminent public danger?
No.
Was he causing serious harm to persons?
No.
Was he causing serious harm to property?
No.
Was he disruptive?
No. Well,
Go ahead.
not, I guess I wouldn't say, I guess that there's room for interpretation on disruptive.
So let me flesh it out with a couple examples. Was he blowing a bullhorn?
No.
Was he bleating like a sheep?
No.
Was he slapping the windows, yelling at jurors?
No.
Were any proceedings disrupted?
No.
You didn't arrest him for disorderly conduct, did you?
No.
You'd agree with me that probable cause is present when you have a belief that a crime is afoot.
Yeah.
Would you agree with me that you did not have probable cause that day to arrest Mr. Law?
I disagree with that.
Yet you would agree with me that on the day that Mr. Lawler was arrested, he was given no contemporaneous order to leave, correct?
Correct.
May I have 1 second, Your Honor?
Of course.
Anything else? I think I'm done. And you agree that after you took him into custody, he's walking, and he says, "You got to give me a warning first." You remember that?
Yes, I do.
And your response to that was, "I did. I gave you a warning in November."
Yes.
I have no further questions, Your Honor.
Any redirect?
Yes. Okay, Sergeant Long, so did you trespass Mr. Lawler pursuant to Ms. Cloud's order?
Yes.
Did we see Ms. Cloud on the body cam footage?
Yes.
Did you speak with her prior to giving Mr. Lawler the trespass order?
Yes, I did.
Okay, are you in charge of courthouse security in the Palmer Courthouse?
Yes.
If a person is going to be trespassed in the Palmer Courthouse, is it your job to issue that trespass advisement?
It is.
Okay, is it Ms. Cloud? Would she go out and issue a trespass back in November of 2023?
Not at that time, no. Typically, I don't know if they ever did in the past, like would go out, but if she or a designee would go out to trespass someone, or when I say go out, if they trespass someone, they would be with myself or whoever, my predecessor or a court services officer.
And just to be very clear, that's part of your job duties, that if somebody's going to be trespassed at the Palmer Courthouse, you would issue that trespass advisement, correct?
Yes.
Okay. And now, this was a question asked in cross-examination. Do you need a warrant to arrest somebody for criminal trespass?
No.
Could you explain that to the court?
Well, I wouldn't if it occurred in my presence, since it's a misdemeanor.
Okay, did a crime occur in your presence in February of 2024?
Yes, it did.
Is that why you arrested Mr. Lawler?
Yes.
Okay, so if you have already issued somebody a trespass advisement and then they come back to that location, do you have to reissue the trespass advisement before you arrest them?
No.
Could you explain why to the court?
Yeah, I guess the best analogy I can give, I mean, I know it's a little bit different if you have, we'll just say a business, if they have a client that shows up that's being, that they don't want there, they're trespassed. And if they show back up, they're given a warning and they're either escorted off the premises. If they don't leave, they're arrested. But if they show up, we'll say 3 months later, they're arrested for trespass because they've been given that warning.
Okay, just to be very clear, we're talking about February now. Did you give Mr. Lawler another warning?
No.
Why did you not?
because he was given the warning in November.
Okay, and you personally advised him of that trespass advisement.
Yes.
Okay, and how long was that trespass for? Or how long was it good for? If you could explain that to the court.
Well, I mean, if he was reading off that printout and it said 2,099, sometimes trespasses are for like a year for residents, or sometimes there are for lifetime trespasses as well. This one here, I mean, if it says 2,099, although I didn't tell someone to put 2,099 in, but I'm guessing it's under the guise as if those two prongs are not met, then it's a trespass.
Okay.
So I don't have that document that he's referring to. Is that something that was given to Mr. Lawler beforehand, or that he got in discovery?
I mean, it wasn't my document that I asked, so I would defer to defense.
It was neither, Judge. This was not a document that was given to anybody. It was only an oral trespass. The document that I have is from the law enforcement notes provided by the state, and I can show it to the court.
My question is whether or not that was given to Mr. Lawler. That's my only question. To your understanding, no.
So it's an oral advisement, Judge. Can I just say what he's referring to? It's absent.
Okay.
Which I would object to that being admitted into evidence given the hearsay. And there's also the case State versus Mattis too, so.
I didn't know if there was an official document that
Sure.
was handed to him. That's what I was just trying to get clear.
So I think, well, I don't want to testify. Could you explain what absent is and why that?
I don't need it now that I.
The court understands? Okay.
Document that was
Understood.
given to Mr. Lawler.
Okay.
I'm good.
Were we in the middle of a question, Sergeant Long? Do you remember?
You just asked to explain the.
Okay.
And I did the best, described it the best way I could. Yeah, I mean, this is in effect till, I guess whenever the court says, hey, we will allow this, then we can always, or when I say we, law enforcement can, have it removed. So other than that, it's in effect till whenever.
Just to be very clear, were you required to give Mr. Lawler another warning when he was in the courthouse recording on February 20th, 2024?
No.
Just to be very clear, you observed him personally recording in November and in February, correct?
Yes, in November, with his actions with the camera, and then he told me he was recording.
Okay. And I think there was a question on cross-examination about whether it could be any other criminal offenses. In your opinion, could it be disorderly conduct to record within a courthouse?
I mean, that was one of the things initially.
I'm going to object to calling for a legal conclusion, a hypothetical.
It's not a legal conclusion. He's trained to interpret statutes, and I'm asking if it could be a crime based on his interpretation of the statutes.
I don't see how that's relevant to what we're addressing today.
It was brought up in cross-examination about he was asking if it's an annoyance or the blowhorn.
I didn't necessarily think it was relevant then, but you didn't object, so I don't think it's helpful.
So the court is overruling?
Yes.
Okay. You waited to arrest him until after you got confirmation that he was recording, correct?
Yes.
Okay, so when we saw you standing outside the clerk's office, had you made your arrest decision at that point?
Is this?
And I'm sorry, we're talking about
Yeah,
the February incident. You and the other officer were standing outside the clerk's office, right?
Right, yes.
You hadn't gotten confirmation yet that he was indeed recording?
Correct.
Okay, and you hadn't made contact with him, correct?
Correct.
Did you go back to your office then to wait until you got confirmation from the court staff that he was indeed recording before you made contact with him?
Yes, or yeah, I was over in my office. I think, well, obviously went to the court, the employee offices.
Okay.
And at some point, I don't remember if it was in the office or over there. I think it was in the office, our office. And then we were notified that he was indeed recording.
Did you confirm just to make sure that he didn't have permission to record from Ms. Cloud or any documents with the court?
That's correct.
Okay, to your knowledge, even after you arrested him back in February, you did a check and there was no indication that he had permission to record.
Yeah, I didn't check. I know the court staff was advised that Mr. Lawler was arrested. No one ever provided me any documentation that he had permission from the court.
Okay, so even from the court standpoint, they were not aware that he was given any prior authorization or permission to record.
Object calls for speculation as to what the court knew or didn't know.
If he has personal knowledge, Judge, he can answer the question if court staff were aware.
If court staff were aware that Mr. Lawler was arrested, that he can answer. What was the?
It was about whether he had permission to record. If court staff is aware.
He already said he did not know. He did not seek that information. Can you restate your question?
Trying to think of how I asked it.
Can you state what was your exact question?
I think Sergeant Long, I asked you if you were aware of whether he had any permission or authorization to record.
I was never informed by the court, or nothing was ever produced to me that he had permission.
Is that sufficient, Judge? Okay. And then I think there's some disagreement about what was contained in your body cam, which the court is going to review on its own time. But in your opinion, do you believe you told Mr. Lawler that he could not record inside the courthouse, even if he was there for official court business?
Correct.
Okay. And was there other people in the clerk's office when Mr. Lawler was recording?
Yes.
Okay.
Yes, there was.
And did we see that in the body cam footage? that there was
Objection, Your
other-
Honor, outside the scope of cross.
You asked about him causing disruption, so I'm gonna allow it.
Okay, you can answer the question, Sergeant Long.
Yes, there was. I don't remember what the last question, but there was a gentleman at least to the left there, in that left window.
Okay. And where his phone was propped up inside the clerk's office, was he recording any individuals or workers behind the desk?
Yes.
Okay. And is that what the presiding order is focusing on with its privacy interests?
Yes, I believe so.
Okay, and why do you believe that?
Because like I mentioned earlier, there are certain areas where there's sensitive information or documents that are being provided, or like the screening area, security measures, or, grand jurors.
Okay. And then is it your opinion today that Mr. Lawler was in violation of the trespass advisement that you had issued him back in November?
Yes.
No further questions.
Briefly.
Thank you, Judge. So, Sergeant Long, when I asked you if he was in violation of a criminal statute, you testified he was not, correct?
Right.
And then when she
Well-
asked you, you said he was.
Just hold on. Sorry.
Wait.
Can he actually have the chance to answer that question?
So,
That's not what his testimony was.
okay. So, a statute versus the trespass statute, you need to be clear. Any other statute besides trespass statute? Because,
Judge, I'm asking him to interpret that stuff, and I believe Your Honor will do a better job than any of us. So I can move on from this whole line of questioning and just ask a couple more things.
And I think it's the court's job or a jury's job to interpret the statute. So Officer Long has testified he believed he had probable cause.
There
It's
will
the
be time
court's.
for argument.
okay,
I'm just
Right.
responding to the objection.
yeah, and, I'm not allowing the question, so he's moving
I'm
on.
withdrawing and I'm moving on. You mentioned an analogy. You talk about how if a business were to call and say they wanted somebody off their property, that they would have law enforcement do that for them. You've brought that up a couple times, right? You brought up a business, you brought up a landlord.
Yes.
You'd agree with me that a business is a private enterprise
Yes.
and that a courthouse is a public place,
Correct.
and those are different things.
Yes.
In November, you warned Mr. Lawler that if he kept up doing whatever he was doing, you were going to trespass him. What did he do when you warned him?
I'm an object judge, so this is just on redirect. And we're way beyond questions that were just in redirect. So these were questions that could have been asked in cross-examination. We're just focusing on redirect, his cross of redirect. And I think we're getting into beyond the scope at this point.
So, this is recross, so I don't even usually allow recross, that I'm allowing it. How is this appropriate in recross?
The state asked Sergeant Long. The state said, Sergeant Long, you had no duty to warn him. Sergeant Long said, yeah, I didn't have to warn him before I arrested him in February because I warned him in November.
Okay,
So-
so what does the duty have to do with your current question?
So I'm going to ask him what happened in November. I anticipate his testimony will be that he warned him and Mr. Lawler left. Then I'm going to ask him in
I
February,
already have all that information.
and then in February that he didn't warn him and didn't give him a chance to leave.
I don't need him to tell me that. I've seen the video and I already know what happened.
And Mr. Lawler was not given a written trespass, correct?
Objection asked and answered.
No, it was never asked and answered. It was,
Written?
I had questions about it, but it was never actually asked of the witness.
So, your question was Mr. Lawler given a written trespass warning? Is that?
Yes.
No.
No further questions, Judge. Thank you.
You may step down.
Exhibit 2, do you want
Yeah,
Leave
you
it
can
there.
get rid of it.
Ms. Martin, any other witnesses?
No, Judge.
Mr. Musa?
No, Your
Any
Honor.
witnesses? All right. So you're not gonna put on the other potential witness?
I didn't subpoena them. I was under the understanding the defense did.
Sergeant Long was rather forthcoming, Judge.
Got everything we needed?
We got everything we needed.
All right, then are we ready to go to argument?
Yes,
Ready,
Judge.
Your Honor.
Would you like a few minutes to organize your notes?
I
or
don't
ready
think so,
to go?
Judge. I'm just gonna mostly rely on my briefing. I think everything has been pretty clearly laid out in the briefing. I think there's actually not even a lot of questions in dispute. It's just whether the court thinks that there was probable cause and whether the court thinks the elements of the statute are met here for the motion to dismiss. So I don't think we need to waste time on oral argument. The briefing is very clear from both parties unless the court has specific questions for me.
I have a feeling Mr. Musa is gonna wanna do a closing, so
Okay.
I'm gonna give you the option to do one as well, but,
No, Judge.
All
I
right.
think it's pretty clear. And I think especially given that the defense has even stipulated that he was recording the meeting, so it's just whether Your Honor thinks it meets elements of the statute, whether there's probable cause.
Thank you, Judge. So, Your Honor, we're asking that the case against Mr. Lawler be dismissed because there wasn't a crime committed. The trespass order was a life-imposed sentence upon Mr. Lawler by Sergeant Long, saying he couldn't appear within the courthouse except on official business. He returns on official business. He's arrested without an investigation. Your Honor, the record evidence established that while he was there to process a citation, there was already a decision made to go 1080 him or arrest him as they walked up to Mr. Lawler, not knowing whether or not he was there on official business or not knowing whether he had permission to record or not. And that's all been testified to here today. And the issue really comes down to us from a legal perspective from the statute 1146-330. And in that statute, it reads that a person commits the crime of criminal trespass in the second degree if the person enters or remains unlawfully in or upon a premises. And then 350 defines what it means to enter or remain unlawfully. And that section reads that as used in 1146-300 to 1146-350, enter or remain unlawfully means to fail to leave the premises that is open to the public after being lawfully directed to do so personally by the person in charge. Your Honor, the seizure of Mr. Lawler's person and his effects was unlawful because the enforcement lacked the requisite probable cause. And that was because his Sergeant Long arrested Mr. Lawler. At that time, Sergeant Long did not know if Mr. Lawler was there on official business. Sergeant Long did not know if Mr. Lawler had permission via that TF 945 form. And further, Sergeant Long testified that under the same basis that Sergeant Long records in the courthouse under the body-worn camera exception to the presiding order. That was actually the one in place at the time both these situations occurred.
So is that different than the one that's been entered
is.
into evidence?
It is, Judge.
So I don't have that in evidence.
Yeah, we were all of us under the understanding that the one that they provided was the one that was relevant at that time, and then all of a sudden I look it up and there's a newer one, so we've all been operating under an inapplicable
I'm confused what defense is referencing.
order. You're the only one.
So his argument is there's the presiding judge's statewide order. The one entered in June is different than the one that you have entered here in evidence, which is
I don't know what he's referencing. I gave defense what was put in the packet for Sergeant Long's incident report and what was provided to defense. I think what he's referencing is not in evidence right now.
Sergeant Long testified that the presiding order that I showed him was the one that was applicable at the time, even though it wasn't the one that.
You showed him you showed him something on your computer that wasn't authenticated. I don't know where that came from. I don't know how I can consider that as evidence.
It's because at the time I wasn't using it as evidence. I was impeaching him that he used the wrong order to trespass him.
Okay.
And then he testified that.
But if your argument is that he was not violating, don't I need to see that agreement? Is that where did you find it?
I found it online, Judge. It's an order. It's a presiding order, but it was just an updated one that was issued in.
So it's on the court system's webpage?
Yes. Order on video recording. It's 5 pages. It was signed on July 24th, 2023.
Any objection to the court taking under advisement that there is a
I would object, this wasn't admitted into evidence, we're done with the evidentiary hearing now, he's trying to get in additional evidence.
Just making sure that we're on the same page, that the public presiding judge's order is seeking to be excluded by the state when the state's only witness testified that this was the applicable order that he didn't know of at the time, but this is the one that applied to both those provisions that Mr. Lawler was arrested for.
I'm not seeking to exclude anything, but during an evidentiary hearing,
so
you
you
have
stipulate?
to,
hold on.
hold on, let me speak. You have to admit evidence. You didn't admit this document into evidence. Now the court is supposed to consider something that's not even in evidence. That's what my objection is.
So are you stipulating to the applicable order that your only witness testified was the one that applied on the 2 dates at issue?
Okay. So you told her this is on the website and she needs a minute to see if this is actually the if this is the order that was in effect. I think that is relevant and I think I do need to consider it, but she needs to be able to figure that out for herself. She can't just,
I showed it
you
to her
can't
before.
just read something.
Agreed, Judge.
So
Yeah, I showed it to her.
you can, what I
Can we
need
take
you
a
to
quick
do.
recess so I can look myself? Like I said, there's no exhibit list right now. I asked if he had an exhibit list, if he was planning to bring any exhibits into evidence. I was indicated it was not. So could we take a little time so I can look myself?
If that's what you wanna do, I mean, although I was gonna say I was gonna let him make his argument and then you can
I would
file
prefer-
something if you
Yeah,
wanna object.
I think that's the best approach. We're already at 154.
Okay, I mean, I don't have hard stop with you, and I confirm everybody else doesn't, but yes.
And Your Honor, based on the state's exhibit list, the presiding judge's statewide order on use of cameras and electronic devices in common areas of court facility is listed as number 2. I didn't know she'd be using one that was inapplicable. That's why I didn't have that printed.
So this is what was given to the defendant by Sergeant Long. That's why it's in evidence. It was given to him by the witness. That's why it's in evidence. I think that's pretty clear.
Okay, the one that is marked as Exhibit 2 is what was provided to Mr. Lawler by Mr.
In November
In
of
November.
2023, correct.
Okay, and it is Mr. Muse's position that that was not the actual applicable presiding judge's order because there was a newer one, and that's what you're gonna have a chance to look at it and let me know if you have an objection to the court taking that in judicial notice that that was the applicable.
Sure, I'll file something if I have any disagreement.
And Sergeant Long testified as such, Judge. He said
Well,
that-
you read to a document that you said, I do that.
Your Honor, the Alaska Constitution guarantees wider Fourth Amendment protections than the United States Fourth Amendment, where as to a person's interest in immunity from police interference, that's from Coleman 553, Pacific 2nd at 46, where the Coleman court held that investigative stops are permissible in cases where the officer has reasonable suspicion that imminent public danger exists or serious harm to persons or property has recently occurred. Sergeant Long testified that there was no public danger, that there was no serious harm to persons, that there was no serious harm to property. So under Coleman, he had no reasonable suspicion to detain Mr. Lawler. Sergeant Long testified that he was committing no serious harm. He testified that the Coleman standard is a flexible one. It must be evaluated under each case's circumstances. Judge, that's from State versus GB, 769 Pacific 2nd, 452 on page 455. That portion reads that to determine whether a stop is reasonable, the court should consider the seriousness of the harm which results from the criminal activity, the recency of the crime, the strength of an officer's reasonable suspicion, and the actual intrusiveness of the investigative stop. There was no recency to the crime because there was no crime. He was Lawler was processing a citation. He was filming. Sergeant Long testified that that in itself is not a crime. The strength of Sergeant Long's reasonable suspicion was non-existent because he testified he didn't know whether or not Mr. Lawler was authorized to record in the courthouse. He didn't ask. And the actual intrusiveness of the investigative stop is at its height because there's no deprivation greater than one's own liberty. And 2 more points, Your Honor, where the court in GB went on where the alleged crime is only a misdemeanor. A minimally intrusive stop based on solid information indicating that a crime has just been completed may be justified. An arrest is not a minimally intrusive stop. It is quite the opposite. Your Honor, finally, the questions about the blowhorn and the sheep and the banging on the glass, I was bringing that up because of the case that defense believes controls here, and that is the case of Turney, T-U-R-N-E-Y, versus State of Alaska. That is 922 Pacific 2nd, 283. A 1996 case, that is a case where a defendant was convicted of trespass, and on appeal that was reversed. And on appeal, the court reasoned that the rules are different in a public place. First of all, the court held that a person being trespassed in a public place must be trespassed contemporaneously, meaning that you couldn't have done it in November because that was too attenuated. In this case, it was an attorney case. The defendant appeared on May 9th and came back on July 13th. And the court said that's not contemporaneous. So a 2-month and 4-day difference was not contemporaneous. Here we've got from November to February, that's a 3-month at least difference. So if 2 months was not contemporaneous, of course 3 months would not be contemporaneous. Your Honor, the court further held that even though in Turney, where the defendant was using a blowhorn, was banging on the window, yelling at jurors, disrupting the courthouse, he was doing all those things, and that was his First Amendment right to express himself, albeit not in the time, place, or manner that was prescribed by the court. That court did affirm Turney's disorderly conduct conviction. There is no disorderly conduct here. So the only issue that is relevant to us in Turney is that trespass, where the court held that a person must be trespassed contemporaneously to the trespass, essentially giving them a chance to leave. And that's why I wanted to ask Sergeant Long that in November you warned him of the trespass, he left. In February, you didn't warn him of the trespass and you arrested him. That's a violation of Turney. And Your Honor, because Mr. Lawler is a member of the public, he was in a public place, he was under compliance of Alaska law, he was under compliance of Sergeant Long's lifetime ban. Further, attorney says you can't have a lifetime ban. That's not a thing in a public place for trespass. Sergeant Long kind of alluded to that when he said you can show up to a medical facility even though you've been trespassing there before. He himself, Sergeant Long himself, caveated this trespass order to say if you're here on official business, testified that Mr. Lawler was here on official business. So under the law, where no person in charge personally informed Sergeant Lawler contemporaneously that he was trespassed, especially considering it was 3 months prior, and under Sergeant Long's own lifelong trespass, unless Lawler was present for official court business, which Sergeant Long testified that he was present on official court business, this motion to dismiss should be granted because even in the state's best case, there is not a law that supports a criminal trespass where Sergeant Long himself testified that recording in a public place is not a crime.
Yes, Judge, 2 things. So I want to point the court to 2 cases here. So the defense is filing both a motion to suppress and a motion to dismiss. Their motion to dismiss is they're saying because there's lack of probable cause that you should dismiss it. That's not how the case law interprets it. I'd like to point the court.
They say not even lack of probable cause, they say the elements aren't met.
Right. So I just wanted to point the court to Greenwood versus State, which is 2012 Westlaw 1994973 in Alaska.
Say that number again.
2012 Westlaw 1994973, an Alaska appellate court decision, May 30th, 2012, and that discusses Holstein, Scoose, and McCracken, and I cite Scoose in my briefing. The remedy for lack of probable cause is not dismissal of the charge, it's suppression of the evidence that the court would find that was not supported by probable cause. So the state is, of course, asserting that there was probable cause, but I just want to make sure the court is understanding that the defendant's requested relief is not how the case law interprets that. So if the court were to grant, again, we're arguing that there was clear probable cause, but if the court is going to say that there was a lack of probable cause, it's not to dismiss the criminal charges then. That's not the requested relief and how the case law treats it. That's Goose versus State, Greenwood versus State, McCracken versus State, all of those courts interpret that exact question, Holstein versus State. They're looking at it in the DUI context for suppression of evidence. So, sorry, did the court have a question?
Yeah, here, what are you saying would be suppressed, whatever they found on the cell phone?
No, okay, so what I'm saying is, obviously we argue that there's probable cause, but in the alternative, the defendant's requested relief and the motion to dismiss is not how the case law treats it. You don't just get an outright dismissal of prosecution for the charges. The court would suppress what it would find would be fruits of the poisonous tree if the court finds that there's a lack of probable cause. But the requested relief of the dismissal is not appropriate. That's not how the case law even treats it as well. The court's actually looked at this argument many times at appellate court and said to the defendants, no, that's not what the requested relief is. You get suppression of the evidence. You don't get an outright dismissal. And I cited that in my motion as well, because I just wanted to.
And if I suppress the evidence, and that means they don't meet the elements of the crime, it's not up to me to dismiss it, or?
No, Judge, and that's not how the case law has interpreted it either. So that was one thing that I wanted to reiterate to the court. And then I also wanted to talk about Turney as well, because there's a clear distinction between the facts of Turney in this case. Turney was talking about being trespassed even for official court business. That defendant was issued a trespass saying he couldn't come there at all to the courthouse ever. He was protesting. They told him, nope, you can't come to the courthouse ever. That's what the Court of Appeals was looking at in Turney. Even the defendant being there for official court business is what he was trespassed on. This is not the case that we have here. Here, Mr. Lawler, he was allowed to go to the courthouse if it was for official court business. There was evidence today that he might have been there for a traffic citation. That's official court business. The state isn't disputing that. But what he couldn't be there for was to record. And that's why there is a criminal trespass charges being filed, because he was there on official court business, but he was recording, which was in violation of the trespass. It was a two-prong advisement. He was told that he could come to the courthouse only if it's for official court business, and even if he would come there for official court business, he couldn't record. That was a two-prong advisement that Sergeant Long gave him. And Turney is talking about a case where he was trespassed entirely, ever coming back from the courthouse. Court of Appeals says you can't do that, which the state agrees. It's a public place. Same with a hospital. Same with the post office, any type of public place. You can come back there if it's for official court business. So I wanted to talk about that because Turney is discussing something that's not applicable to what we have here. Here we have a caveat where he could come to the courthouse for official court business, and Turney was not considering that because that was not the advisement the defendant and Turney was given. So I just wanted to clarify that caveat with Turney. Thank you.
All right, Ms. Markson, how long do you need to confirm that that is the operative?
10 minutes. 5-10 minutes.
Okay, so you'll file something by the end of the day today if you
Oh.
object to it.
Oh, sorry. Okay, well, I have to get back to Palmer.
That's what.
Yeah, could I have till Friday? I'm actually starting a jury trial tomorrow morning at 8:30 as we speak, so could I have till Friday?
Any objection? So I'm not. You're starting a jury trial tomorrow?
Correct.
All right, let me know by Friday at noon if you are going to object to the court considering.
Yep, we'll do. I'll just file something in writing if you don't hear anything by 4:30, the state doesn't object.
And just confirm like where you found it and which document so that I know where to find it.
Okay.
I don't think Your Honor needs this, but I just don't want to leave it unresponded about this notion that Your Honor can't dismiss charges if they don't meet the elements.
I know how to read things. Okay. All right, anything else?
No objection.
Should we set a next hearing? So I think we set it as a status, but if I don't agree and don't dismiss the charges, I think this case needs to be moving towards trial pretty darn soon. So I'll set it for 30 days, which I think is my deadline for getting an order out, and that will ensure that I get my order out. And then at that point, that will be kind of a last status, and if I haven't dismissed it, then we will be looking at going to trial. Okay?
Okay.
Alright, status on May 22nd at 4 p.m.
Your Honor, may I hear telephonically?
You may. At the
May 22nd at what time?
4 p.m.
Okay.
That work?
I think so. If it doesn't work for my schedule, somebody will call in for my office.
Okay.
We have scheduled pretrials. The court has been setting the pretrials on Monday during the Palmer block. And so I have over 400 cases that I sit in from 8:30 to 4:30 on Mondays, and that's why I haven't been able to call in, is because you've been setting them during the Palmer pretrial block.
Okay.
So I appreciate when you don't set it for a Monday, because that helps me out a lot, and then I don't have to try to find coverage.
Alright, we will do it on Thursday.
And I think 4 p.m. is great as well, because jury trials go from 8:30 to 1:30 in Palmer, so that way
They do yours.
I should be able to call in on the 22nd, telephonically. Thank you.
And if I have not said it, Mr. Musa, and as long as we're doing pre-trial issues, you can appear telephonically. If this case goes to trial, we're gonna find the Palmer courthouse in the courtroom, that's what we'll be doing.
Understood.
Alright, that will go off record, I'm good to go.
Thank you.
Off record, stand Lisa.
Hey, thanks for watching, you guys. This is the end of the courtroom videos. I do have more on this. I have security cam footage from inside the courthouse. That will be the next video coming up, along with my body cam footage, witness testimony, and other documents. Do me a favor, you guys. Like, share, subscribe, leave a comment down below. Let me know in the comments what you guys think about all this. If you'd like early access to videos like this and more, the members tab is open, and donations are greatly appreciated. So until next time, thanks for watching, and I'll see you guys in the next one. Later.